Question number 76. Which of the following is the most appropriate? The institution of appeal does not by itself operate as stay of the decree appealed against. Option second, the appellate court has the power to stay the execution of the impunged decree. Both first and second are correct. Only one is correct and only second is correct. In question 76, third option, that is both the statements are correct, is the right answer. Question number 77. Rejection of an application for leave to sue forma pauperis is a decree, not a decree, may or may not be a decree depending on facts, none of the above. Question number 77, correct answer is second, not a decree. Forma pauperis is a Latin term meaning in the manner of pauper, allowing a poor person to bring suit without liability for the cost of the suits. Now let us see the question number 78. Legal heirs must always be the legal representative in civil suit. The statement is correct, partly correct, incorrect, none of the above. Answer is incorrect, because according to section 2 subsection 11 of CPC, a legal representative is a person in law who represents the estate of a deceased person. This includes anyone who interferes with the state of a deceased person as well as the person to whom the estate devolves upon the death of the party. Question number 79. When a suit is filed against a minor represented by his guardian, the decree passed in the suit will not operate as res judicata, will operate as res judicata, will not be binding on the minor if he files a suit on the same cause of action within 1 year of becoming major, none of the above. In question number 79, the option second is the right answer, will operate as res judicata. Question number 80. At times, proceedings are adjourned sine die on account of stay. Even after stay is vacated, intimation is not received and proceedings are not taken up. In an attempt to remedy this situation, we consider it appropriate to direct that in all pleading cases where stay against proceedings of a civil or criminal trials is operating, the same will come to an end on expiry of 6 months from today unless in an exceptional case by a speaking orders such stay is extended. This observation was made by the Supreme Court recently in which of the following cases? This observation was made by the Supreme Court in Asian Resurfacing of Road Agency Private Limited versus Central Bureau of Investigation 2018. Question number 81. A partner who retires from a partnership firm, such partner is no longer liable for debts or liabilities of the firm toward the third person from the date of his retirement. Options are yes, a retiring person is no longer liable because his liability is only till he continues as a partner of the partnership firm because of section 13 of the Partnership Act. Option second, yes, he is not liable because after his retirement from the firm, the other partners no longer can act as the agents of the retiring partners as per section 18 of the Partnership Act. Option 3, a retiring partner is only liable for debt liabilities of the firm to a third person till a public notice is given of his retirement in view of section 32 of the Partnership Act. Liability of the retiring partner will continue unless public notice of the retirement of the retiring partner of the firm is given both by the retiring partner as also by the partnership firm. In this question, correct answer is option 1. Yes, a retiring person is no longer liable because his liability is only till he continues as a partner of the partnership firm because of the section 13 of the Partnership Act. Question number 82. Person is liable as a partner of a partnership firm only if he is a partner by an express written contract. Option, no, a person is liable as a partner by an implied contract provided thereafter the implied contract is got registered before the sub-registrar. Option second, no, a person is liable as a partner even by holding himself out as a partner of the partnership firm but only to that person who has on the faith of such holding out has given credit to the partnership firm. Option third, a person who holds himself out as a partner will be liable as a partner of the firm only when the third person who deals with the partnership firm has informed a person holding out that he is acting with the firm on the basis of such holding out. Option 4, a person holding out is liable to a third person only if the third person has given a public notice. According to section 82, the question asked about an express written contract. The correct answer is option second. No person is liable as a partner even by holding himself out as a partner of the partnership firm but only that person who has on the faith of such holding out has given credit to the partnership firm. Question number 83. Is it correct that in a contract of sales of goods under the Sales of Goods Act, if the goods received are not as per the terms of the contract, then the buyer in all cases has no liability to pay for the goods which are received by him from the seller? Option, yes, he is not liable because no buyer can be imposed a liability for receiving contracted goods. Option second, yes, he is not liable till he gives intimation in writing of acceptance. And option third, yes, he is not liable if he has intimated the seller within the reasonable time that the goods have been rejected. And option 4, no, he is liable because of the principle of buyer beware. Correct answer in question number 83 is option 3rd. Yes, he is not liable because he has intimated to the seller within reasonable time that the goods have been rejected. In a contract of sale of goods under the Sales of Goods Act, there can be stipulations both in the nature of conditions and warranties. Option 1. Yes, in a contract of sale there can be stipulations which are both in the nature of conditions and or warranties. Option 2. With respect to the sales of goods under the Sales of Goods Act, if the contract is an international contract, only then can the contract contain conditions and warranties. With respect to the sales of goods under the Sales of Goods Act which are in the form of bullion or jewelry, only then can there be both conditions and warranties in the contract of sale of such goods. Conditions and warranties in a contract of sales of goods can both exist provided the warranties are those which are only those written on a stamped agreement duly notarized as per section 85 of the Indian Evidence Act. Here the correct answer is option 1. Yes, in a contract of sale there can be stipulations which are both in nature of conditions and or warranties. Now let us see the question number 86. When the specific goods which are the subject matter of the contract under the Sales of Goods Act have perished prior to the making of the contract, then contract can be enforced against the alternative goods because the contract of sales of goods otherwise valid. Options are: no, the contract of sale of specific goods cannot be enforced because goods have already perished without the knowledge of the seller at the time of the contract, and then the contract of the sale itself is void as per section 7 of the Sales of Goods Act. Option 2, though ordinarily the contract of the sale cannot be enforced against alternative goods instead of the contracted goods which have perished, but the alternative goods can be received by the buyer from the seller if the value of the specific good is less than rupees 100. Option 3, if the specific goods have perished before making of the contract and this was a fact already known to the buyer but not the seller, then the contract is not valid with respect to the claim of the buyer for alternative goods. Option 4, a contract for sale of specific goods which have perished prior to the entering into the contract for sale will be void and can be enforced against alternative goods only if the buyer has possession of the alternative goods. Here the correct answer is option 1. No, the contract of sale of specific goods cannot be enforced because goods have already perished without the knowledge of the seller at the time of the contract, and then the contract of sale itself is void as per section 7 of the Sales of Goods Act. Question number 87. There is no distinction between a sales and agreement to sell under the Sale of Goods Act. Option 1. Yes, it is correct because parties must always act in furtherance of the intentions to complete their obligations under agreement to sell. Option 2. There is a distinction between agreement to sell and a sale under the Sale of Goods Act because property, title in the goods which are subject matter of the agreement to sell will only pass when the time lapses or conditions are fulfilled, subject to which property in the goods is to be transferred and thereafter the agreement to sell matures into sale. There is option 3. There is no difference between a sale and an agreement to sell because both such contracts are automatically unconditional. And option 4. There is no difference between the sale and agreement to sell under the Sale of Goods Act only if such contracts are those with respect to the perishable goods. Here the correct answer is 2nd. There is distinction between the agreement to sell and sale under the Sale of Goods Act because the property, title in the goods which are subject matter of the agreement to sell will only pass when the time lapses or conditions are fulfilled, subject to which property in the goods is to be transferred and thereafter the agreement to sell matures into the sale. Question number 88. During investigation by a police officer under the directions of the magistrate on complaint of A, alleging criminal misappropriation of his diamond ring by B, A produces an invoice evidencing his title to the property. The invoice is found during investigation to be fabricated. On closure report, the magistrate took cognizance and summoned A to face trial on the charge of fabricating false evidence. The contentions of A are: the document invoice was not given in judicial proceeding, the police officer has not made a complaint. Here options are: both A and B are correct, only A is correct, only B is correct, both A and B are incorrect. These both statements will be incorrect. Option 4 is the right answer. Now let us see the question number 89. A was working in an institution. He withdrew certain amount of money with the permission of the head of the department for disbursing it amongst other employees. However, he took the money home and used it for his urgent need. A month later, he brought the same amount from his home and disbursed it amongst the rightful recipients. He has committed option 1, no offense, option 2, offense of 3rd, and option 3, offense of criminal breach of trust, and option 4, offense of criminal misappropriation of property. Here the option 3rd is the right answer with offense of criminal breach of trust. Criminal breach of trust is given in section 400 of IPC. Section 400 of IPC of criminal breach of trust says that whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged or of any legal contract express or implied which he has made touching the discharge of such trust or willfully suffers any other person so do commits criminal breach of trust. Question number 91. In P. Ratinam versus Union of India 1994, the Supreme Court held that Section 309 IPC is unconstitutional. Was this judgment overruled, and if so, in which case? Here the correct answer is yes, Srimati Gyankaur versus State of Punjab 1996. Question 92. The word injury under the IPC denotes only physical injury, only physical mental injury, only harm to body and property, harm to body, mind and reputation of property. Here the correct answer is 4. Section 44 of IPC talks about the injury. The word injury denotes any harm whatever illegally caused to any person in body, mind, reputation or property. So the correct option 4 is the correct answer. Question number 93. Which of the following does not constitute secondary evidence? Option 1. A photograph of the original document taken on a smartphone. A copy compared with the original document made by copying machine. A copy transcribed from a copy not compared with the original. Oral evidence regarding the context of a document by a person who has seen the original document. Here the correct answer is option 3. A copy transcribed from a copy not compared from the original. This will not constitute secondary evidence. So this is the right answer in the questions asked. Secondary evidence is the evidence that has been reproduced from an original document or substituted from an original item. Section 63 of Indian Evidence Act explains about the secondary evidence. Match the following items. Theft, taking without consent, criminal misappropriation of property, only movable property, criminal breach of trust, entrustment of property, cheating. Answer is deception, cheating, D. Question number 95. Fill in the blank. When the question is whether a man is alive or dead and it is shown that he was alive within dash, the burden of proving that he is dead on the person who affirms it. Answer is 30 years. Question number 96. Fact under section 3 of the Indian Evidence Act means the truth as proved in the court of law which helps of witnesses, facts as narrated by the client to the lawyer, belief of a person in the existence of certain things, anything, state of things or relation of things capable of being perceived by the senses. This option is the correct answer related to fact. Question number 97. Options are match the two columns: rebuttable presumption, irrebuttable presumption, conclusive proof and proved. Rebuttable presumption, correct answer is A. Court may presume a fact unless it is disproved. Irrebuttable presumption, court shall presume the fact unless it is disproved. Conclusive proof, court shall not permit evidence to the contrary. Proved, court believes it to be exist or consider its existence probable. This is the correct match. Question number 98. A will can be proved at least one attesting witness being examined. Therefore, where both the attesting witnesses have died, the will cannot be proved. Is this statement correct? No. The signatures of the attesting witnesses and the executant can be identified by the person acquainted with signatures of the attesting witness and the executant. Question number 99. In a suit for partition, a memorandum of family settlement is filed, and on this basis the partition suit is decreed. But even after disposal of the suit, the original memorandum of family settlement remains in the file of the partition suit. Then in such situation, whether in a suit for eviction by one of the original co-owner of a tenant of a shop of the joint property which has fallen to the share of that co-owner as per the decree passed on the memorandum of family settlement, can the certified copy of the memorandum family settlement be filed and proved as a public document in the suit against the tenant? In question number 99, the correct answer will be no, it cannot be, because the original memorandum of family settlement document which exists in the suit for partition which is disposed of is a private document and not public document under section 74 of the Indian Evidence Act. This is the correct answer. Now let us see the question number 100. Power of attorney is presumed to be correct if it is attested by the oath commissioner, if it is executed before and authenticated by a notary public, if it is attested by two witnesses, if it is registered. Here the correct answer is option second, if it is executed before and authenticated by a notary public.